India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here's the headlines. Supreme Court accepts DGCA's recommendation on airfare refund. Travel agents to get refund only for tickets booked by them during lockdown. Customers to get back refund money. Supreme Court quashes Gujarat government notification exempting factories from paying overtime wages to workers during COVID lockdown. Directs government to pay overtime wages to workers for that period. Prashant Bhushan moves Supreme Court seeking review of judgment imposing ₹1 fine on him to contempt of court. Plea filed in Madras High Court against NEET norms for forcing married candidates to remove sacramental chains before exams. Plea says violates religious rights and dignity.
India Legal presents Courts Roundup.
The Supreme Court has accepted all recommendation made by the Director General of Civil Aviation regarding refund of airfare to passengers for tickets booked during the COVID-19 lockdown. The bench of Justice Ashok Bhushan, R. Subhas Reddy and M.R. Shah clarified that tickets booked through travel agents will be refunded to them and not directly to the passengers. The Supreme Court has ordered the refund of fare for airline tickets that were booked during the COVID-19 lockdown period. A three-judge bench of Justice Ashok Bhushan, R. Subhash Reddy and M.R. Shah has reserved its order on September 25th on a plea filed by NGO Pravasi Legal Cell, who had contended that non-refund of the amount of tickets by airlines was illegal and violated the requirements issued by the DGCA. The court has issued the following directions. If a passenger has booked a ticket during the lockdown period from 25th of March 2020 to 24th of May 2020 for travel for both domestic and international air travel, and the refund is sought by the passenger against the booking being cancelled, the airline shall refund the full amount collected without any cancellation charges. The refund shall be made within a period of 3 weeks from the date of cancellation. If the tickets have been booked during the lockdown period through a travel agent, all such cases full refunds shall be given by airlines immediately. On such refunds, the amount shall be passed on immediately by the agents to the passengers. Even for the international travels, when the tickets have been booked on an Indian carrier during the lockdown period for the travel, within the lockdown period, immediate refund shall be made. The airline shall make all endeavors to refund the collected amount to the passenger within 15 days from 1st October. The credit shell issued in the name of passenger shall be transferable, which can be utilized up to 31st of March 2021. The court said that the second respondent, Directorate, shall ensure strict compliance of the directions referred above by issuing necessary instruction to the all concerned. Bureau Report. The Supreme Court has quashed a Gujarat government notification exempting factories from paying overtime wages to workers and providing ideal working conditions to them amid the COVID-19 lockdown. The court has also directed the government to pay overtime wages to workers for that period. The bench of Justices D.Y. Chandrachud, Indru Malhotra and K.M. Joseph ruled that the pandemic cannot be a reason to junk statutory provisions that ensure dignity and right to proper wages to workers. The order was passed in a petition challenging the state government's decision to exempt factories from the provision of Factories Act relating to work hours and other benefits. The bench has further noted that the statutory rights of workers could not have been set aside by the Gujarat government as the pandemic is not an internal emergency threatening the security of the country. While reading the verdict, Justice Chandrachud stated that the court is aware of the financial hardship faced by factories due to the slowdown in economic activities during the lockdown. However, the burden of economic slowdown cannot be put on workers alone, who are the backbone of economic activity, the court ruled. During the nationwide lockdown in April this year, the Gujarat government issued a notification exempting factories in the state from certain provision under the Factories Act between April 20th and July 19th. This notification was passed by the state in purported exercise of its power under Section 5 of the Act. The notification essentially exempted factories from the mandate to comply with the provision of the Factories Act, which deals with payment of overtime wages, working hours fixed for the workers, resting intervals, etc. The petition filed by the Gujarat Mazdoor Sabha and the Trade Union Centre of the India says, while granting this exemption to factories, the state government also did away with the requirement of payments of double wages for overtime and allowed for overtime hours to be compensated at normal working wages per hour. This notification was challenged on the ground that the state has acted ultra vires the act, considering the fact that Section 5 only allows for exemption in cases of public emergency. The COVID 19 pandemic, while being a critical issue affecting the country, has still not been declared as an emergency. Therefore, the state government could not have exercised this power under Section 5 of the Factories Act. The plea filed through advocate Arpana Bhatt stated, the provision under Section 5 allows for an exemption to be granted to factory or a class of factories. However, the notification under challenge has given a blanket exemption and is therefore liable to be quashed, the petitioner further contended. The court said it is amply clear that the Gujarat government has misused Section 5 to suspend key provision of the Factories Act 1948, which offers basic and fundamental protections to workers, especially in time where workers are most vulnerable economically and socially. Bureau Report. We are now joined by Advocate Shivam Sharma. Shivam, please update us on today's court proceedings.
Yes, in this case, the court has said that the shocking extension of working hours is being directed at a time when the most basic medical and scientific advice to contracting the delay COVID-10 is to be rest and stay as healthy as possible. This new regime ensures the complete opposite as per the notification. This worker will now be overworked without being compensated for the same as per law, which will only ensure that both their physical and mental health deteriorate. The court further said that Section 5 empowers state government in case of a public emergency to grant exemption to any factory or class or description of factories from all or any of the periods of the Act, subject to a period not exceeding 3 months. In light of this observation, the court has quashed this notification. Yes.
Thank you, Shivam, for the update. Now, moving on. Advocate Prashant Bhushan has moved the Supreme Court seeking a review of its judgment of August 31st, which imposed a token punishment of ₹1 fine on him after finding him guilty of contempt of court. Bhushan has also prayed for an open court hearing of this review petition and for the larger question of constitutional importance pertaining to contempt of court to be referred to a larger bench. In the instant review petition filed through Advocate Kamini Jaishwal, Bhushan argues and that in the sentencing, the court has imposed a fine on him and in the event he defaults, he was liable to be barred from appearing before the apex court for a specified period of time. The petition said at no point was petitioner put to notice that the court was contemplating such a drastic action against him. He further argues that he was prevented from filing an additional reply before the court when his preliminary reply was found unsatisfactory. The court's sentencing was based solely on his preliminary reply, and the denial to allow him to lead evidence is also a violation of the established rule governing the contempt procedure. Bhushan further said the court ruling that a sentence of imprisonment would be imposed on him if he defaulted in payment of the fine is disproportionate and contrary to provision of the Code of Criminal Procedure. A group of distressed seafarers and merchant navy officials moved the Supreme Court against a finance ministry notification that denied them any tax relaxation for a 60-day period within their 182 days or more stay in India for the financial year 2019-2020. As per the notification, they are to be assessed for that period for income tax. The court has issued notice on a plea which challenges the validity, legality and propriety of the letter issued by the Government of India declining tax relaxation to the seafarers. A bench of Justice Rohiton F. Nariman, Naveen Sinha and K. M. Joseph sought the centre's response on the petition filed by Advocate Raj Kishore Chaudhary on behalf of the Merchant Navy Officers and Ladies Association. The petitioners have submitted that on 8th of May, the Ministry of Finance Department of Revenue, Central Board of Direct Taxes issued letters declining to provide tax relaxation to them for the said period. This is for those who stayed for more than 182 days in India during the financial year. According to the letter, they will have to submit to income tax assessment of the year 2019-2020. The petitioner said that the letter ignored the factual situation that the COVID-19 outbreak was witnessed across the whole world in the month of December 2019. The petitioner included those who are currently staying in India and hence income tax laws are applicable to them. The plea said that the officials could not go on board due to the lockdown. The Supreme Court in its judgment has granted conditional premature release of convicts who displayed good conduct during their sentence of nearly 2 decades in prison. While granting this early release based on good conduct, the Supreme Court said that a balance between individual and societal welfare can be struck through this move by ensuring that the convicts no longer suffer a curtailment of their liberty and are also not a threat to the society. This verdict came from bench of Justices N.V. Ramana, Suryakant and Rishikesh Roy that said that the convicts who were serving term for their crime of kidnapping for ransom have suffered the consequences of their action while being in prison for 2 decades. During this period of over 20 years, the conduct of these 2 convicts had been more than satisfactory, according to the affidavit filed by the state of Uttar Pradesh in this regard. Including a period of remission, they have served a total of 22 years in prison and still have substantial years ahead of them, with the convicts being about 54 and 43 years in age. The case made out against their release by the state harbored on their young age. However, the court's view was different, which said that it is in the fact on the account of the age of the convict that the matter needs to be viewed through the prism of positivity. The Supreme Court has refused to entertain a petition seeking a commission of inquiry probe into the government's alleged mismanagement of the COVID-19 pandemic. The bench of Justice L. Nageshwar Rao and Ajay Rastogi declined to entertain the petition, remarking that it was not a subject for the court to venture into. When advocate Prashant Bhushan, appearing for the petitioner, questioned the government's handling of pandemic and the unilateral decision of imposing the lockdown, the court also noted that the question raised in the PIL pertaining to the National Disaster Management Plan, among others, already stand addressed in the judgment rendered by a bench headed by Justice Ashok Bhushan earlier this year. The plea filed in July sought the constitution of a commission of inquiry to look into the gross mismanagement of the COVID-19 pandemic by the central government. The petition stated that the announcement of the first lockdown with a mere 4-hour window was arbitrary, irrational and without due consultation with experts or state governments. The petitioner had added that the court, in its capacity as a parent partia, must direct for constitution of a commission to look into the government's lapses. In a letter addressed to Chief Justice of India and his companion judges of the Collegium, 47 lady advocates have sought for constituting a High Court monitor investigation and trial to ensure strictest and swiftest possible punishment to the accused in the Hathras gang rape case. The letter further prays for immediate inquiry and suspension or any punitive action against all erring police, administrative and even medical officers who may have tried to manipulate the facts and evidence of the case. The lady advocate also seeks setting up of adequate institutional mechanism and guidelines so that no other victim or their family feel lost when it comes to the law and order situation in our country and suffer the same fate. Hoping for urgent intervention by the top court, the letter reads, "We are writing to you out of much anguish and distress over the manner and procedure in which situation has been progressing with respect to the tragedy that struck a 19-year-old Dalit girl from Hathras, UP. Highlighting a series of incidents, the letter draws focus on the police response to the situation. The letter stated that after September 29 this year, when the victim succumbed to her injuries at Safdarjung Hospital, the action of the police officers seems unfathomable and raise many questions which intervene between our rule of law and our nation's humanity." And now it's time for a short break. We'll be right back.
India Legal presents Courts Roundup. India Legal presents Courts Roundup.
Welcome back. After married women were made to remove their thali, sacramental chains worn by married women before being allowed to write the NEET this year, a plea has been moved in the Madras High Court challenging the dress code imposed by the National Testing Agency for the medical entrance exam. The petition moved by Chennai-based advocate S. Arvind Raj asserted by forcing married women to remove their thali to write the exam, the religious rights, personal sentiments and dignity has been violated. Apart from informing candidates that there will be extensive and compulsory frisking, this provision also states that light clothes with long sleeves are not permitted. Ornaments, metallic items are prohibited, Clause 8(1)(e), stating that similar torture may be continued in the future. Also, the petitioner has now challenged these provisions as unconstitutional before the Madras High Court on the following contentions. The conditions stipulated are very vague and very general, leaving the students in the name of the checking. Frisking, the students are put to all kind of rigorous tortures due to the dress they wear. Female candidates were harassed to the greatest extent just an hour before the examination. Hindu married women in India strongly believes that the wearing of thalis is a sacramental aspect and part of their religious belief. By forcing students to remove thali and commit such anti-religious act, it is a violative of religious right guaranteed under Article 25 of the Constitution. The High Court of Kerala has refused to stay the investigation by the Central Bureau of Investigation in the Life Mission case. Considering the petition for admission, a single bench of justices, V.G. Arun, said that the court cannot interfere with the investigation at this stage and that it needs to wait for more details to emerge. The bench orally remarked, "Let the investigation go on." The bench added that the CEO has not been named as an accused and that he has only been summoned to produce certain documents and he should cooperate with the probe. The Chief Executive Officer of Life Mission Project under the Kerala government has approached the High Court seeking to quash the FIR registered over alleged violation of FCRA in relation to accepting foreign donation from UAE. The plea seeks to quash the FIR registered by the central agency on September 24 to the extent it relates to public servants under the government. Life Mission is a housing project mooted by the Kerala government for the benefit of the homeless. Alleging that foreign contribution to tune of 10 lakh Arab Emirates dirham were transferred to the private contractors Unitech Limited and Saint Ventures in violation of FCRA norms, a legislator belonging to the Congress party, Anil Akara, filed a complaint before the CBI on 20th of September. The decision of the West Bengal state government to ban the use of cell phones inside the hospital premises and in particular the hospital where COVID-19 patients are admitted was challenged in 4 writ petitions. Such a decision was contained in the government order dated April 22, 2020. The Calcutta High Court has expressed hope that the state government shall take such appropriate measures without compromising the health issues of the public at large to ease out to the ban on use of mobile phones in hospitals, since the same definitely causes the inconvenience and other problems for the members of the society. The bench of Chief Justice T.B. Radhakrishna and Justice Arijit Banerjee further stated that the state government should follow any directive advisory issued in this regard by the appropriate department of the central government. The order was passed by the state government on the basis that cell phones could be carriers of coronavirus. The contention of the petitioner was that the decision to ban the use of cell phones in hospitals is arbitrary and without any basis. The petitioner said unless such a patient is a permitted user of the cell phone, he will be totally cut off from his family. It was alleged that by imposing such a ban, the state government has illegally impinged upon the right of free communication, which is a fundamental right of every citizen of India, including the patient infected with COVID-19 and their family members. The case of the state government was that in the wake of the outbreak of the COVID-19 pandemic, the government adopted such measure as it thought would be the best interest of everybody concerned. In the ongoing probe of Baroda custodial death case, the Gujarat High Court has reminded the investigating officer that truth is the motto and object of every investigation, and in the instant case, all the accused are police personnel who are supposed to be well versed with all possible tactics to overreach the process of law. Extraordinary care would be expected on his part. A petition was preferred by the petitioner Sheikh Salim Sheikh Babu, who was aggrieved by the fact that his father, namely Sheikh Babu Sheikh, is missing since 10th December 2019. It was further his grievances that he repeatedly approached the respondent, police authorities, and also gave written application, but no heed is paid to his request and not a single reply is received with regard to the whereabouts of the corpus. Till date, the police machinery couldn't trace the missing person in question despite court's several orders to this effect. Significantly, on 5th of August this year, the court acceded to the request of change of investigating agency rather than permitting some more time in the matter to the present agency, as that may further result in loss of vital evidence. The court ordered that the investigation be handed over to the CID crime. The court was provided with the roadmap of investigation, and it was ensured that the best possible endeavors would be made to go to the root of the matter. And that's it for Court's Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.